The European Court of Justice today invalidated Safe Harbor, an agreement that allows US tech companies like Apple and Facebook to transfer the data of European customers to their servers in the US. So, what is Safe Harbor? Safe Harbor is a regulatory framework that allows US-based organizations to overcome the restrictions on transfers of personal data from the EU. Theoretically, it ensures that the personal data of users in the EU is protected when they use sites like Facebook or Apple. Under Safe Harbor, US firms must abide to several specific data requirements that are much tougher than those already in effect in the US. Thursday's ruling says the bloc's national data authorities can override the 15-year-old Safe Harbor Pact used by around 4,500 companies. What are the objections to the Safe Harbor Pact? The ruling is seen as a victory for privacy advocates. They say that the pact exposes EU users to allegedly indiscriminate surveillance by the US government, most notably because of the Edward Snowden revelations, which show that the NSA accesses data from internet companies in the US. Will EU users still be able to use Facebook and Amazon? Yes, as long as US firms can provide safeguards to protect EU users' personal data, even when processed in the US and in accordance with US law. But the reality is that US companies can't provide absolute guarantees that the US government won't access the data of their European users. Neither, by the way, can European firms guarantee that European governments won't access their own users' data. These firms can look to an alternative legal basis to legitimize the transfer of data to the US. EU data protection law provides for other alternative methods to companies to validate transfers of personal data outside of the EU. These include model clause agreements and binding corporate rules for intra-group data transfers around the world. But the implementation of these alternative mechanisms may have a disproportionately larger cost or resource burden for small and medium-sized businesses and startups and developers. Big companies like Microsoft and Facebook can and do afford to set up data servers on European soil, and they can hire big legal teams. Smaller businesses and startups can't afford that. What's at stake? The ruling adds urgency to the scramble by companies as well as the US Commerce Department and the EU's executive arm to preserve the freedom of data between the EU and the US. Hanging in the balance is a trade worth billions of dollars in online businesses and e-commerce and the ability of users in the EU to use US websites.